pronouncing my name spot on.
Yay!
So I have a boatload to go over, probably too much that I'll be able to fit. But without further ado, I'm gonna jump right in. So I'm going to start. My section is on living trust structures and provisions. I want to start with a little bit of proviso. I listened in on the previous presentation, and I saw some folks had what appeared to be some pretty sophisticated questions. I have tailored, this was more of an overview, so I've tailored my comments more on a general basis. But if you have a technical question or something that goes beyond the scope of what is relatively broad presentation, my email is at the beginning of this, and never hesitate to shoot me an email and I'll be happy to fill you in to the extent that I can. So, inter vivos trust. What is an inter vivos trust? It's, as I said there, it's a trust that's established when a person is alive. And there are a million different reasons, well, maybe not a million, but quite a few different reasons to create inter vivos trusts. One of them is for asset management. One is for Medicaid planning. There are times to do it for estate taxes, but it's really not, to be honest with you, the use of an inter vivos trust for estate taxes is quite limited. You can create inter vivos trust for the benefit of special needs trusts, so that a person can continue, if you have a person who is disabled or incapacitated or receiving governmental assistance, they can continue receiving that governmental assistance, and you can establish a separate trust during your life. When I say, I go into this a little bit more later in detail. Before going forward, one of the things that I want to touch on is very frequently people come to me and say, hey, I need a living trust. I need this trust. I need that trust. Before you jump right in, I caution you, a lot of times, Google Esquire gives folks some legal advice that really doesn't suit their purposes. Before establishing an inter vivos trust, there's one of the things you want to know is how sophisticated is the client that you're supposed to be helping, and the other issue has to do with fiduciaries, trustees. Do they have availability of somebody who is in fact trustworthy? Is that person going to administer it? Certain types of trusts, in particular special needs trusts, really require affirmative steps to be taken in order to properly administer them, and it can be a real pain in the neck. Other issues is do they really need it? And I bring this up because here in New Jersey, there are a lot of, like I said, a lot of people come to see me saying, hey, I want to set up a living trust to avoid probate. And you may live or you may practice in a jurisdiction where that very much makes sense. Here in New Jersey, the probate process is not all that complex. It's an administrative application you make to the county surrogate, and it's not that it's not that difficult. It's not that awful. Where they make sense, Florida, I've dealt with Florida and New York. The probate procedures there are more complex, they're more expensive, and in those states it might make more sense for you to do a living trust. I recommend that if you don't know it already, find out how complex your state's probate procedure is, and that it might give added incentive to do a living trust. We don't do them as much as here. I'm a New Jersey attorney. My observations are guided by 27 years of practicing in this state. I've done most of my presentation today. I've based on the Uniform Trust Code. Not all the states have adopted it, but most have to some degree or another. So keep that in mind. What I tell you today, I'm doing my best to be a broad brush, to give it to you in a broad brush. I suspect that the concepts that I'm giving here will translate along all states with the possible exception of Louisiana. But even probably then. But for the most part, what I say on a broad brush level should apply to you. And I recommend that before you leap in and make a recommendation on one of my observations, that you check your local, check the probate code in your state. So, revocable trusts. What is a revocable trust? A revocable trust lets the grantor get whatever assets he or she has placed into the trust. Why have one? I just mentioned avoiding probate and to check your jurisdiction's requirements. Frankly, what I just discussed there, I should have just hit this next button sooner. A revocable living trust, the biggest reason to have it that I'm aware of is avoiding probate. Revocable trusts don't do a heck of a lot otherwise. There are first off, there's no estate tax advantage to it. There is no long-term care planning advantage to it. It doesn't protect you for any grantor trusts. It doesn't protect from any creditors that you might have. And it's also can be a pain in the neck. It costs more to create them than a simple will does. At least it does in my practice. And there can be, there's also additional burdens. People often create these trusts and they don't fund them by retitling assets. And in essence, they end up paying a boatload of money to a lawyer, they end up paying money to a lawyer only to have a piece of paper after they die with their loved ones thinking that, administration is going to be a piece of cake. Now, in my opinion, far more useful are irrevocable trusts, all right? And these are ones where the trustee can't demand it back. And I put demand it in italics because there are there are ways around having some, you don't have legal control over, a grantor doesn't have legal control over the asset once he or she transfers it into the trust. But that said, depending on who you appoint as your trustee, more often than not, there's not restrictions on the trustee giving it back to you. So why have an irrevocable trust? First off, estate taxes. You reduce the size of the taxable estate. Currently, the estate taxes are taxes that are imposed on the value of an estate when it exceeds a certain amount called the unified credit. And I know that my predecessor touched on this a bit, at least to some of it. I heard him talking on a number of related issues. If you have an estate worth more than $13.99 million right now, you're going to have to pay federal estate taxes. This amount is scheduled to sunset at the end of this year. People are ballparking around $7 million. But there's it's a politically driven beast, the amount of the unified credit. And there's a decent chance that Congress and the current administration will extend that threshold. Some states also have a state tax. We used to have one in New Jersey that was $675,000, but it was rescinded in at the end of 2018. But I've listed some of the other ones that do have estate taxes. And again, I'm a New Jersey guy. So don't listen to what I'm saying to lead you to the conclusion that you don't need to worry about estate taxes. Just because I don't here in New Jersey doesn't mean that you might not have to. The next reason to have one is for long-term care and a Medicaid application. And I go into that in some detail later, as I do with special needs. Now, the irrevocable trust is a gift to the trust, but it has conditions in it. And what are the conditions of the gift? You're giving it away, but you as the grantor can retain some degree of control over the assets. You can set forth this is how it's to be administered. You can make it so that there's an income provision only. So, for example, you can put X number of dollars, $1 million into a trust in order to get it outside of your estate, let's say for Medicaid purposes. And after 5 years, that will be outside of your estate. And you can retain the right to have income paid to you. And, in addition to you being able to collect income, there's an added benefit. I heard my predecessor speaking about the stepped up basis. If you have a properly drafted income-only grantor trust, when you pass away, even though you've given this gift away, and you are continuing to collect income from it, when you pass away, if it's drawn properly, your beneficiaries will get the benefit of a stepped up basis and pay less capital gains taxes when they sell. There are other conditions that you can put in this gift, certain powers of substitution. You can substitute out beneficiaries of the trusts. There's powers of appointment, and I talk about both of these a bit more later. What are the concerns? What are you worried about when you create an irrevocable trust? First off is, you do have the loss of control. And you see I have the same line, do you have trustworthy kids? And I say trustworthy kids because, at least in my practice, 4 out of 5 times it is the kids who are going to be named as the trustees, adult kids. And what I ask the clients is, do you have a kid that you're concerned about who's not going to a kid is not going to have your back, is going to prioritize their own needs over yours, or B, even if they would prioritize it, are they bad with money? Are they spendthrifts? Do they have gambling issues, etc.? The other issue that I talked about is when you do these trusts, if they're not properly drafted as a grantor trust, the gift to the trust could be treated as a gift during life, and the kids could lose the stepped up basis. So before you fund and make a gift to an irrevocable trust, you want to make darn sure that that your trust is set up properly to preserve the stepped up basis. And you can do this by having an income only trust, or there are certain powers that you can keep, a power of appointment, a power of substitution that allows you to put some assets into the trust, take some out. You take some of the trust assets back out of the trust, but you have to substitute it with a similar asset of equal value. Also, the last thing you saw earlier, my predecessor mentioned the possibility of a higher income tax rate on a trust. Okay, one of the issues we're supposed to touch on is the trust situs. Where is it going to be? Where is it located, and where is it to be administered? And this is an important thing, because the absent an express choice of law provision in a trust, more often than not, the trust situs is going to determine what law applies. Now, you can have, I could have a New Jersey trust that expressly states the trust is going to be governed in accordance with New York law. And what that means is the trust might be operated here in New Jersey, pay taxes here in New Jersey, et cetera. But if there is a dispute or if there is a problem, it would be in accordance with New York law. That's an unlikely example, but there could be reasons why you would do it that way. When you don't have an express situs provided, if you don't say where it's from, the Uniform Trust Code provides for considerations, and the default rules are the trustee's principal place of business, place of administration, and like I said before, a choice of law provision. So going back to it, if you have a New Jersey, you have a trust with no situs provision in it, but there's a choice of law that says it's to be construed in accordance with Florida law. It will likely but not certainly be treated as a Florida trust. There are other considerations beyond the scope, like where everything is located. If you have a trust that is it's a trust created in Florida, it is a trust that has a Florida choice of law provision, but no situs provision. Beneficiary and everybody else is located in Vermont. Beneficiaries can argue that it should be administered and litigated in a Vermont a Vermont court using Florida law. But basically, trust situs is a provision in the will to establish where the trust is to be administered. Related to that is the choice of law, which law governs. And as I said before, there's nothing that prohibits prohibits a Minnesota trust from electing to use Delaware law. Usually the Minnesota court will honor that and will construe the trust in accordance with Minnesota law, unless there are exceptions in cases of fraud. If their chosen law has got no nexus whatsoever to the trust, those are the biggest exceptions. Again, why would you have an express choice of law provision? One of them might be for taxation, and this is a bit of a reach. Some states don't have income taxes on trusts. If you had property, if everything is located, let's say in North Carolina, you have a taxation, or you have a choice of law provision that states Alaska and Florida, and everything is located in another state. You can bet your bottom dollar that that state is going to take the position that those assets should be taxed and that a tax return is due in that state, notwithstanding the fact that there's a reference to Florida law. Why also have an express provision? Possibility of disputes. An example would be there are in terrorem clauses which say that if somebody disputes a trust after a person dies, that if they try to dispute it or they try to dispute a will, that they're disinherited. Such provisions in New Jersey are void as a matter of public policy. But there are other states where they are allowed, and you may wish to adopt for that reason the law of another state. Okay, we go through. I sent out in your materials. There should be the sample trust. I'm not going to go in light of my limited time. I'm not going to go. You can read these, what I've itemized here, and compare it with what I sent in the materials. And if you have any questions as to any one of those provisions, let's say you look at my language for termination and you have a question, shoot me an email, because we've got a lot to go over, and I'm happy to answer any questions that you might have. Okay. those are key positions. What I listed here are standard provisions that are in almost every trust. I'm going to talk about some specialized provisions. And, I put on my snooty law professor hat and quoted William Blackstone. The fact of the matter is within, so long as you're not violating public policy, if you know the law, you can get very creative in the drafting of a trust. So I have listed a number of examples of specific provisions you might put into a trust, and I got them listed right there. And I'm going to go over some of them now. Powers of appointment allows the power holder how to direct how certain trusts are going to be distributed, either at life or during death. So, for example, you can give your trustee a power of appointment over whether or not to name somebody as a beneficiary of the estate. What letting a power of appointment do is it allows you to make decisions based on circumstances that might occur in the future without having to go back to a lawyer to avoid the trust. You can do it for tax planning. Right now, it may be that they adopt the law down the road that would make it better to direct, to take assets out of the trust, to transfer the trust in certain ways, or to transfer assets away from the trust in certain ways, based on the changes in the law. It also will be, if you have a family member who's turned against you and you wish to disinherit them, or alternatively, you've got somebody new you'd like to include, a power of appointment would allow that to occur. Another issue that arises, especially in terms of special needs trust, is a trust protector provision. What it is you name in a trust, often, especially with special needs trust, what I frequently do is I try to name a family member or somebody close to the disabled or incapacitated person who can keep an eye on how that person is doing. Now, there are other trusts. There are other considerations, especially in what's called a first-party trust, where if you make certain distributions, they could violate what the requirements are for making distributions and jeopardize the beneficiary's entitlement to governmental benefits. So because you often have two people appointed, sometimes there's disagreements between the personal trustee, the family trustee, and the professional trustee, or maybe the family thinks that this professional trustee is charging too much. Whatever it may be, you can appoint an independent person who's really usually a lawyer and can be you if you're drafting these documents, with the power to amend the trust and/or appoint other trustees, to take care of changes in circumstances. Another example in a special needs trust is that often special needs trusts are established for young people. You may have a 19-year-old kid who with cerebral palsy who qualifies for Medicaid or Social Security disability. And you may have appointed that person's parent as the trustee, or a grandfather, an aunt, and they pass away, and the trust doesn't make sufficient provision and there's no one else available to do it. you can have a trust protector you can have a trust protector name a new executive, or a new trustee. Another reason is to fix drafting errors, ambiguities, etc., without either having to hire a lawyer or without having to go to a court. Because if you don't have a trust protector with the ability to make such amendments, you often will have the trustee, especially in New Jersey, may have to make an application to the court to either construe the trust a certain way, or to amend it, as the case may be. Okay, the next issue is what is a pour-over will? As the name suggests, it's a provision. It's a provision in a will that says that any asset. Let me rephrase that. That's a mistake on my printout. I apologize. It's a provision in a trust that says any assets remaining get passed in accordance with the person's estate plan under their will. It can also be a provision in a trust going the other way, to avoid fragmented estate administration. Next up, special needs trust. Special needs trust is, as I said before, you could have somebody who is on a needs-based, receives needs-based benefits, such as Medicaid. And if they come into a lot of money, they're going to lose their entitlement to Medicaid. Here in New Jersey, and I believe in most states, a single person can't have any more than $2,000 in their name, and a married couple can't have any more than $3,000 in their name in order to qualify for Medicaid. There also there's a supplemental security income that can be inhibited if you come into too much money. So what a special needs trust does is it creates a second trust. It creates a trust and funds it with separate money or assets to supplement what that person receives from the government. And there are two types. The first part is a first-party special needs trust, which is a self-settled trust. And where this often occurs is when a person is the victim of an accident, and they recover a lot of money, for example, in a personal injury suit. And due to that suit, they're disabled, and they now get Medicaid, or they now get Social Security, et cetera, or Social Security income. And in that case, if they take the money outright, all of that money is going to go towards their medical care. Their long-term care. So what a person can do if they are going to receive a substantial amount of money, they can take the assets, the disabled person, and place it into a first-party special needs trust where somebody else has control to enhance their quality of life. So, for example, Medicaid is going to pay for that person's, let's say that their nursing issues, or for their medicine, or for other issues, health-related issues. For, let's say, if they had to go into a residential facility, Medicaid will pay that. But let's say, the person would like to have a nice new television, or they'd like to have a car. They have the ability to earn a living and get around, but they still need the assistance of the government in paying bills. You can use the special needs trust to make that person's life better. Now, the one big thing with the first-party special needs trust is there's got to be a provision in the trust that says Medicaid gets paid back when the special needs person passes away first. So the purpose of a first-party special needs trust is not asset preservation for the benefit of family beneficiaries down the road, brothers and sisters, for example, of the special needs person. Rather, it's to make that person's life better during their life, and then to the extent that the government has laid money out, they get paid back first. Medicaid gets paid back first. The other type of special needs trust is a third-party special needs trust, and this is funded with assets of somebody other than the beneficiary. And here in New Jersey, that person has to be the parents or the grandparents, unless you make a court application. So I can't set up a third-party special needs trust for my buddy unless I make an application to the court here in New Jersey. And this third-party special needs trust is similar to the first-party special needs trust in that you can use it to make the first party the special needs person improve their life, give them a vacation, give them a more comfortable room, buy them furniture, do whatever. The difference with the third-party special needs trust, however, is when the special needs person passes away. At that point, dad or mom or grandpa, grandma can have the remainder of the trust go to his or her heirs. Okay, trust funding. This is a big issue that you see a lot. People spend a lot of money getting an awesome estate plan where they're supposed to fund things, and then they come and it turns out that they never properly funded the trust. The trust only controls assets that are transferred into it. Otherwise, it's an empty vessel. So common assets, you might say, often this is a problem after a person has died, and folks come and say, well, we don't need to worry about paying estate taxes because we had an irrevocable life insurance trust, and they never had the life insurance placed in the name of the trust. Or it might say the trust says the house is supposed to be left to Sister A, but the house was never placed into the trust, and consequently it passes under the will, and it goes to Sister A and Brother B. It is very important if you establish any kind of trust that you make sure that your clients fund it, and I hold their hands to do it. You got to make sure they're retitled. You got to redeed real property, retitle bank accounts and investment accounts, and look over have your clients show you the documents as how they have it titled. I give a printout when I do a trust for a person, letting them know I do the deed, but for bank accounts and investment accounts, sometimes I'll email the financial advisor or I give the client a printout. This is how you should have your assets titled. And then I even have them email the stuff back to me or get things back to me so I can make sure they're properly titled. You can, with assets that are often placed in trust with some alternatives, there are tax-deferred annuities. You can name a trust as a beneficiary if you want. For example, you can have an asset left to a trust. You may want to leave an asset to a special needs trust for the benefit of a grandson or whatever. You can name that trust as a beneficiary. Okay, so it actually looks like I went too fast. I have another 10 minutes on here. Let me go back. I apologize, folks. I've been rushing. So one of the issues that often occur when you fail to fund a trust is it often leads to litigation. And as I'm going to talk about when I go over executor duties, estate litigation is a pretty big part of my practice. And not funding a trust the right way, where it was clearly your notes say that this is what the testator or that the settlor wanted. He wanted the house to go to one daughter, and he wanted the rest of his estate place to go to his 3 children in equal shares. And he takes the house and he puts it in a trust, a Medicaid asset protection trust, for example. And names his one daughter who has lived in that house and taken care of him as the beneficiary of that estate. As the beneficiary of that trust. So she gets the house and the other kids don't. So, and in addition, he puts a bank account in there where he wants that bank account only to go to the daughter who is taking care of him. That is clearly what the settlor wanted to do, and under his will, he leaves everything in equal shares to the trust. You give him instructions. This is what you got to do. Go to a real estate attorney, deed the property over into the trust, and you go to the bank, and here is here is how you should have your bank account set up going forward, in the name of the trust. You go through and do all of that. The person doesn't do anything about it. They pass away, and then the daughter who took care of him is expecting to inherit all of this stuff. The trust is empty, and it's going to pass in accordance with, at least the other children are going to argue it passes in accordance with the probate estate, and it's to be distributed equally amongst the kids. And that is an alert your carrier situation. There's going to be litigation over what was the testator's intent, and whoever loses that litigation there's a very good chance they're going to assert a claim against you for tortious interference with an expectancy or something similar to that, and it's going to create problems for you and your malpractice policy. So I can't emphasize enough. So often lawyers who don't do a fair amount of probate and estate law fail to do this. And frequently I get these beautiful binders filled with wonderful documents that purport to do all of this sort of thing, to do all wonderful things. And lo and behold, it isn't funded. And best case scenario, they're coming back to you looking for a refund on your legal fees. Worst case scenario is you're faced with a lawsuit. So also going back into one of the things that I want to talk on here on this note is naming assets in the name of the trust. You can have, for example, a tax-deferred annuity, okay? And in that annuity, you might want to name the trustee as a beneficiary. The trust as a beneficiary. There can be advantages to doing that as part of your plan. One other thing that I do want to go over, and I apologize that I went so fast. I have more time than I thought. As far as going with powers of appointment, you also have the ability to change the terms of the trust to reflect changes in circumstances. One of the issues that I talked about by having a power holder is you can keep this stepped-up basis in Medicaid planning. Medicaid planning, going back, again, Medicaid planning really wants a person to give away their assets. They are, in essence, bankrupting themselves. They want to take a $5 million asset, put it in the name of a trust, 5 years passes, and then they say, well, I only have $2,000 in my name. So consequently, I should only, I only have $2,000 in my name. And thus, I don't need to worry about paying my long-term care bills, for example. Let's say a person has dementia. One of the issues you want to prove to Medicaid that the person truly gave this asset away. And Medicaid turns over every last, they gave it away and they did not maintain any control over it whatsoever, regardless of how much time has passed. So I mentioned earlier things that you can do to preserve the stepped-up basis in a Medicaid application. One of the things that you can do is have a general power of appointment, which allows you to maintain a level of control, and that is going to pass Medicaid. That's going to pass Medicaid Medicaid threshold. So you will be able to qualify for Medicaid, even though you have kept a certain level of control over the asset. Other than that, the next section that I want to touch on is our executor and trustee duties and responsibilities. I went over a bunch talking about the living trust. Again, if you have any questions or issues or comments, please, I'd love to talk about it. If somebody does a lot of this, feel free to email me. So the next issue we're going to talk about is executor trustee fiduciary duties and responsibilities. And I do a fair amount of probate litigation out here in New Jersey, and this is always an issue. This is an issue frequently that comes up in terms of claims of breach of fiduciary duty, objections to accountings, and the like. So first off, in New Jersey, there's an executor or an administrator, and they're a person of an estate for somebody who has passed away. And an executor is a person who's appointed under a will. An administrator is appointed under the intestate statute. Intestacy is the estate plan that the state has written for you if you don't have a will. Trustee is a person who is appointed under a trust agreement, as one would guess. So whereas both personal representatives, and when I say that, I'm speaking of both executors and administrators and trustees, whereas they're both fiduciaries, they're both held to a higher level of care, and they both have many duties in common, there are some things that are different. And largely it's due to the fact because trustees, are generally it's something that's occurring, that are not dealing with the administration of a dead person's estate. So what does a personal representative have to do that a trustee usually doesn't? Their job is they got to apply to probate to get letters of administration or letters testamentary issued. And then the job is, in a broad brush, is then collect the assets, pay the debts, and distribute the assets in accordance with the terms of the will and the law if there's no will. The personal representative has an end game. All right. The likelihood is their administration. The rule of thumb is it's got to be done in 1 year. At least that's how it is in New Jersey. You can't file for an accounting before the expiration of 1 year. So basically, a personal representative looks at their venture as a short-term operation where they're going to collect assets, sell them off, sell off what needs to be sold off that's not specifically bequeathed, pay the expenses, pay the taxes, distribute the assets, and then close up the estate. Hopefully you get a refunding bond and release from a beneficiary to close the estate, or if a beneficiary has problems, then or has issues, then you can file an action for an accounting to get an approval. So next up are, as opposed to the responsibilities of a personal representative, the trustee usually, not always, but usually is looking for long-term administration and investment. A real common one is the example of a children's trust. You've got a testamentary trust and a will that says if I die and I'm leaving $1 million to my kid, but if he or she is under the age of 30, then I appoint a trustee to manage the estate. The person dies when the kid is a little baby, 4 or 5 years old. That trustee is going to have a job that's going to last for a decade and a half. So that's one of the things that a trustee has to deal with that a personal representative does not. It is generally a long-term venture. It does not, and anticipates many decisions, many different circumstances arising over the years. Next up are discretionary. There are discretionary distributions and ascertainable standards that a trustee generally has to adhere to. An executor or an administrator only needs really to admit to, like I said, pay everybody who's owed money off and distribute the remainder to the beneficiaries. Well, with a trustee, a proper trust is going to suggest, I'm not going to suggest, will often mandate standards by which the money is to be managed, the money is to be distributed, and otherwise handled. The common broad brush one is particularly when you have a trust for the benefit of kids, say, is the trustee has the sole discretion to make distributions for the health, maintenance, and education and general welfare of the beneficiaries. That's a real broad one. But you may have some mandated ones. For example, depending on the circumstances, the trustee may have the obligation to pay all income over to the beneficiary, or all income over to the grantor in certain circumstances. They may have an obligation. There's something called the 5 and 5 obligation under a estate tax unified credit trust, where they have to give income or up to $5,000 a year, 5% of corpus or $5,000 a year to a beneficiary. There also can be some provisions in the trust in which there can be some provisions in the trust whereby the trustee mandates how certain assets are to be controlled or invested. I'm not a big fan of these particularly when the trust is to be maintained after somebody dies. There's, a sort of a macabre saying of describing exerting too much control over assets as you die as administering the trust from the grave. But if you have somebody, there's nothing that prevents you have a client who is absolutely wants to make sure that all money is placed in blue chip stocks, you can provide for it. There are a number of different limits, governors, standards, et cetera, that you can impose into a trust that you wouldn't see as part of an executor's obligations under a will. Okay, so what are the duties of any fiduciary, both trustees and personal representatives? First off is the duty of loyalty, okay? And these are called fiduciary duties. This is what forms the basis of most actions against fiduciaries for breach of fiduciary duty. One is you got to avoid self-dealing and conflicts of interest. And frequently you'll see provisions in a will that will even allow the trustee to make gifts to him or herself. And, that's generally okay, but, that is something that you need to be very, very prudent with, even if the trust allows it. Self-dealing, I'm speaking, obviously it's clear that if a person cuts a check to themselves and runs with it, that's clearly an example of a breach of fiduciary duty. But sometimes it's not as clear, and the duty of loyalty, the duty that a trustee or a fiduciary owes to his or her beneficiaries is tantamount. There is another duty that you have for a duty of care. Oh, if assets are not titled in trust names before, with the pour over will clause in the will, transfer them to the trust. If assets are not titled in the trust's name before death, with the pour over clause in the will, transfer them to the trust upon death. If the answer to that is yes, if the will so provides. The answer to that is yes. But the will must provide for that. And that, by the way, is a catch-all way of dealing with dealing with assets that may have slipped through, that you may not have put together in the trust. Getting back to the duty of care, there may be investment standards like we talked about. Frequently, there is the Prudent Investor Act or Prudent Investor Rule that might be imposed by the trust. I frequently, on a bigger trust or trusts that are more sophisticated, will tell a trustee to either hire a professional or delegate it. Sometimes I'll have the trust provide for co-trustees, as I mentioned earlier, one in the name of the have co-trustees, one who handles finances and the other who handles the personal needs of a beneficiary. Duty of impartiality, no favoritism. And you can have a beneficiary who is a pain in the neck, who drives everybody crazy, who is an awful human being in all respects, but under the duty of impartiality, your fiduciary has to treat that person equally. Generally, I don't like to make distributions, preliminary distributions before the settlement of an estate. If you want to make a partial distribution of half the money, give it to everybody at the same time. An awkward situation can occur sometimes. Let's say you want to make a distribution. You've got a big estate that's going to take years to administer, and you've got $1 million in cash, and we've got 3 kids, one of whom doesn't trust the other kids, and the other kids are the fiduciaries. You want to make a distribution to them, but the troublesome kid won't sign off on a refunding bond and release. If that happens, the other two fiduciaries have every right to their money at the end at the end of administration, or if you want to do it before then, they have a right to get their money. And you're placed in the tough position of, if you give money to the two kids who accept the accounting, you're in a difficult position of that there then being an action from the disgruntled sibling that he has been treated or she has been treated unfairly, that there have been examples of favoritism, etc. So one way to handle that situation is, at the end of administration, if you can't get everybody to sign off on an accounting, to sign off on the accounting, you can submit that accounting to the court for its approval. Before the end of administration, you could submit an interim accounting, but you look, rather than doing it in terms of an interim accounting, which can be expensive and detailed, should be detailed, an interim, you make an application for instructions from the court to say, hey, it's okay for you to make this distribution, to everybody as you're proposing, even though this other beneficiary disagrees. So that picks up on the next issue is the duty to inform and account. Now, I've dealt with both trusts and estates where beneficiaries feel that they have the right to speak on and be included in every last decision, and that's not the case. A fiduciary, however, does have the obligation to keep beneficiaries to respond to their reasonable requests, to provide a timely accounting. Generally, if a year doesn't pass, or if a year passes, a beneficiary has the right to demand an accounting. If less than a year has passed, they have the right to compel an accounting in examples of if there's special circumstances. The accounting, you have to keep it you have to be able to answer it in the correct format. You just often, people will submit a Excel spreadsheet showing where all the money went. And, generally, particularly on a more sophisticated estate or one where there's contentions, I want to see underlying documents. I want to see bank statements. This is if I'm challenging it. And if I'm representing a fiduciary, I implore them, keep thorough documents, keep everything that anything that you feasibly could think would answer a question that a beneficiary might have regarding the way that you handled an estate. And as part of that, for example, let's say part of the estate is you, in lieu of giving somebody money, you had the right as the executor to give them a house in lieu of money. Well, if you are going to do that, you should have an appraisal as well to support that. Frankly, I wouldn't do that without having court approval anyways, unless the will was really clear. But your accountings should be thorough and should be supported by the documents. Don't just give them printouts, and don't just give them certifications saying, well, it was fair market value. Attach the associated supporting documents. And the other thing is I periodically, even if nobody is asking, I usually have my fiduciaries shoot out a letter, depending on how sophisticated the estate is, every 6 months to a year, letting everybody know what the status of administration is. if you're affirmative, it decreases the likelihood of there being suspicion or bad faith on the parts of any of the beneficiaries. The next is the duty to administer the governing document, whether it's a trust or a will, according to its terms. There's another question. Is a trustee of a trust and/or executor of a will required to disclose assets not administered by probate or trust, such as assets scheduled with beneficiaries? If heirs beneficiary request, does she have to disclose those assets of the decedent? That's an excellent question. The personal representative is only in charge of the probate estate, and they're only required to account for the probate estate. So the easy answer to your question is no. The trustee does not have to disclose any assets that weren't under his or her control. That's the easy answer, and it's the general rule. But as we all know, there's gray areas and exceptions to every rule in the law. What happens? Sometimes I've got an example now where I have a out-of-state bank where it is an asset that we know passes outside of the estate, but won't release anything unless they have letters testamentary from the executor. Now that's flat out, in my opinion, against the wrong. It's unlawful. They shouldn't be doing it. And I have a choice: either have my client make an application, get the will probated, and give the company what they're looking for, or institute an expensive legal proceeding to compel with an order to show cause to compel the financial institution to pay the money over. Obviously, I'm going to go, absent odd circumstances, I would go with having the executor, make that application, get that information, and and assist in getting that money into the hands of the beneficiaries. Where that could be a problem is the troublesome beneficiary making issues. Well, they didn't account for everything. They had control over the asset. Nobody was listening. Nobody at the banking institution was listening to anyone but the fiduciary. They need to show that, they need to show documents. In that case, you might have to account for the fact that even though the fiduciary was involved, it's not a probate estate. So if heirs beneficiaries request that he executor of a will. Oh, this is good. Okay, if heirs beneficiaries asking for a copy of the state tax return, does that need to be given? Beneficiaries trying to learn who received what from the decedent. So that's another great question, and it's one that comes up a lot. Again, with the troublesome beneficiary. The executor or trustee has an obligation to keep beneficiaries informed in accordance with their reasonable requests. 9 times out of 10, 19 times out of 20, they're going to have a right to see the tax return. The issue, though, is when. What I don't want is a squeaky wheel beneficiary questioning every last decision of my fiduciary. So I would deadleg somebody who is difficult in getting a tax return. I would tell them you're going to get it at the end when we prepare an accounting. Because the beneficiary is trying to learn who received what from the decedent. Absent a specific bequest, the beneficiary of a residuary estate, where they will get whatever is left over, has a right to look into that, to make sure that, that they're getting what's coming to them. So listen, err on the side of transparency to avoid, give them whatever information that they're looking for to avoid claims against your fiduciary down the road, but try to be timely and sensitive with it. One of the things that you can ask is, you tell the fiduciary who may have his or her lawyer writing you for this information, look, you're going to get everything at the end before an accounting, or when we submit the accounting to you, you're going to get everything at the end, and all you're doing now is running up the estate's attorney fees and legal costs. Sit tight. But if they really, it's a question of reasonableness, which everybody knows, the reasonable person standard is certainly subject to various interpretation. But, general rule, yeah, they get to see it. Caveat is try to be sensitive to the timing of it so as not to arm a troublesome beneficiary. So getting back to the duty to administer the trust and estate according with its terms, this is really, self-explanatory. Where you could get in trouble, though, is the second line, interplay with state law and court orders. You may have a will which has a provision that's void under public policy. You don't see it as much anymore, but if you go back into old wills, you'll see, provisions based on race, on religion. This person isn't supposed to get it because of this, because of that, and that's a problematic provision. But as a general rule, if a trust says that you have to give this money to person X or do that with charity Y, you have to do it. Okay. We have a Q&A of what if beneficiaries of non-probate assets and don't want information disclosed on a state tax return? That's a great question. And that's a tough one. And I'll tell you what, in that situation, depending on how difficult it is, I probably would, in that case, take the position that I would document the money that is to be paid to the federal government for estate taxes using a different methodology other than giving them the Form 706. I might initially just redact the portions that apply to non-probate assets or trust assets, and redact everything but the numbers that solely apply to the probate assets, give that to the other attorney, and have him or her persuade the client that this is all you're going to get. Or if it is applied to, and short of that, have them make an application to court. If I had a beneficiary of non-probate assets that I disclose on a Form 706 or a transfer inheritance tax return, and they didn't want it reported, unless that beneficiary was the fiduciary, if it was somebody else, I probably would tell that beneficiary or his or her attorney, I'm going to give you the return. It's going to be redacted for any non-probate asset or non-probate issues. And if you don't like it, go to court and try to compel me. And I would argue about it in court over that. And the advantage of doing it that way is also if you have, because I have the situation now as it is. I have my lady is the executor. Her sister set up all of her assets to pass by operation of law, mostly retirement accounts, to my lady, who is the sister and also the executor of her will. What she didn't do is what I was talking about earlier. She created a trust to put her house in and never deeded the house over to the trust. So that trust is passing under her will, and everything goes to the 5 siblings, including brothers. Now, we had to do a transfer inheritance tax return on this, and the sister doesn't want her brothers to know about it. And I'm not disclosing it, but in that situation, since she is the recipient and I'm worried about self-dealing, if it comes to it, I probably would have her disclose it. But other than that, if it wasn't my client who was the beneficiary and it was another third party, I certainly would make that, I would either make the complaining beneficiary make an application to the court to compel my client to turn it over, or I might make an application, probably would make an application myself to the court for instructions. And the reason I probably would do it the latter way, as far as me doing it myself, is it allows me to frame the arguments for the court and anticipate any objections that the troublesome beneficiary might have. That's a really awesome question, and it does arise in terms of non-probate assets, and it also brings up another interesting issue. You may have a probate estate that is not wealthy enough to pay estate debts. And in New Jersey, under the banking code, and then also under the probate case law too, if there's not enough money to pay in the probate estate to pay all the debts, especially taxes, you can make an application to have assets that pass outside the estate cover them. And we're not today. Hello? Well, my camera went dark for a second. I apologize. You may need to get a beneficiary's assets that pass outside of the estate. You may need that to pay transfer inheritance taxes on that asset alone. A transfer inheritance tax is paid to a beneficiary based on their relationship to the decedent. And if you have, for example, a bank account that passes to a beneficiary and there's a tax imposed on that, and there's not enough money to pay in the probate estate otherwise, you, as the fiduciary, may need to force that person to pay their share of the transfer inheritance taxes. And that might take a court application. So the interplay between probate and non-probate assets or trust assets really makes a very interesting interplay in dealing with this and in representing fiduciaries, because often they need to get involved to cause the transfer of the assets, but theoretically they're not required as a fiduciary of the probate estate to address them. Okay, I have another question. You mentioned a will and a trust where the will transfers property. Is this not a pour over will into the trust? That is what I typically, what are your thoughts on a pour over will with a revocable trust? Yeah, you mentioned a will and a trust where the will transfers the property. Is this not a pour over will into the trust? The answer to that is yes, and that is what you typically use. Yes, that is a pour over will, and the thoughts on the pour over will with a revocable trust. If you are in a jurisdiction where revocable trust makes sense, that's absolutely a legitimate way of handling it. Again, I don't use a revocable trust all that much because I'm a creature in New Jersey, and as I said, our probate procedures aren't that big a deal. But yeah, no doubt, using a transferring property with a revocable trust into a pour over will, it's certainly something that many practitioners do. Okay, hold on. Bear with me, folks.
We're actually at the end of our time.